Welcome to today's webinar brought to you by DISA Global Solutions. Today's presentation is entitled Oklahoma Legislative Update and will discuss medical marijuana changes in the workplace. I'm Jessica Polk of the Current Consulting Group, and I will be conducting today's presentation. If you have any technical problems seeing or hearing today's webinar presentation, please use the chat section to alert us to your issue, and we will attempt to resolve the problem. This presentation will be recorded, and you will receive information after the webinar on how to access that recording. Today's presentation is brought to us by DISA Global Solutions. They are a provider of workplace safety and compliance services with more than 30 years of experience. Every year, DISA helps thousands of companies make more informed staffing decisions by offering a broad array of industry-leading screening and compliance services. With DISA, you can maintain a strong DOT compliance program while keeping your focus on the rest of your business. As part of our comprehensive compliance services, DISA will not only supply you with official regulatory agency policies, but will help you complete and manage them too. Let us know how we can help you with any of the following agency policies and requirements: Federal Aviation Administration, Federal Motor Carrier Safety Administration, Federal Railroad Administration, Federal Transit Administration, Pipeline and Hazardous Materials Safety Administration, U.S. Department of Homeland Security, and U.S. Coast Guard. We make sure that you have the information and resources you need to conduct your day-to-day business. Today's presentation will be brought to you by Bernard and Katherine Miller. Bernard is a highly accomplished operations and compliance executive with a distinguished career at Walmart, the U.S. Department of Labor, and U.S. Department of Housing and Urban Development. Frank is currently the Vice President of Ethics and Compliance at DISA Global Solutions. Frank is responsible for translating DISA's compliance vision into actionable strategies that support client performance, enhance program maturity, and create competitive compliance advantages. These strategies encompass the compliance subject matter areas of DOT and transportation compliance, training and education, employee screening, and risk management. Katherine Miller is the Social Media Director for the Current Consulting Group, or CCG. She manages updates across social media networks as well as promoting partners' content. She manages CCG's and clients' newsletters and blogs, edits industry publications, researches industry changes, and manages content to keep clients informed and up to date. Katherine regularly authors articles, white papers, and infographics on drug and alcohol testing available in publications across the industry and creates infographics for publication and training. Katherine is an expert in state laws and regularly consults with clients on state law questions. It will now be our pleasure to hear from Bernard.
Thanks, Jessica. I wanted to thank everyone for joining us on the call today. During this call, Katherine and I will take the opportunity to discuss the following agenda items. We will discuss marijuana in 2018. We will specifically discuss Oklahoma State Question 788. We will discuss states with similar medical marijuana language. And most importantly, medical marijuana in Oklahoma and next steps forward. Next slide, please. As we think about the history, in particular, of medical marijuana, over the last 50 years, our country has had a dynamic history around the legalization of medical marijuana. This all started in 1970 with the Controlled Substance Act, which classified marijuana as a drug with no accepted medical use. Then towards the late 70s, early 80s began the legalization of medical marijuana only for the purposes of research. This happened in New Mexico in 1978 when they passed the Controlled Substance Therapeutic Research Act. Virginia followed shortly thereafter, and South Carolina followed with the Controlled Substance Research Act of 1980. These acts, as I stated, were specifically focused on research and research purposes only. The first states to truly legalized medical marijuana. This occurred in California in 1996, as California was the first state. Alaska, Oregon, and Washington followed thereafter. Alaska, Oregon, and Washington followed in 1998, and all three of these laws were passed on the same day. As I bring your attention to the map of marijuana in 2018, I think it's pertinent that we identify or call out there are currently 9 states with legal, recreational, and medical marijuana laws on the books. Oklahoma is the most recent state to legalize medical marijuana. Multiple other states have recreational and or medical marijuana initiatives that will be decided in 2018. An example of this would be North Dakota, where they're going to continue to evaluate full legalization. That gives us a full perspective of marijuana as it relates to 2018. With that being said, I'd like to transition over to specifically talk about State Question 788. Now I'll turn the call over to Katherine to discuss Oklahoma State Question 788. Katherine.
Thanks, Frank. So we're going to be doing a little bit of an overview of State Question 788, as well as a deeper dive into what the language means for employers and some states with similar language. So without further ado, we're going to jump right in. State Question 788 passed on June 26th of this year with a 57% majority. It allows medical marijuana card holders to possess up to 3 ounces of marijuana on their person, 6 mature marijuana plants, 6 seedling plants, an ounce of concentrate, 72 ounces of edible marijuana, and 8 ounces of marijuana in their particular places of residence. The most impactful part of this particular legislation is that the way that State Question 788 passed and how it was worded means that there are no qualifying conditions for medical marijuana in the state of Oklahoma. So any state resident could go to a physician and ask for a quote unquote prescription. And if the physician deems that that person could benefit from medical marijuana, they can get that recommendation regardless of what condition they might have. This makes Oklahoma's medical marijuana program one of the least regulated in the country. So a little bit of a timeline. As I said, the State Question 788 passed originally on the 26th of June of this year. On July 26th, the application requirements and instructions were made available for patients, caregivers, growers, processors, and dispensaries on the Oklahoma Medical Marijuana Authority website, as well as the Food Safety Board members were identified. The Food Safety Board has just started meeting now. On August 25th, so coming up later this week, interested parties are going to begin being able to submit applications via the Oklahoma Medical Marijuana Authority website. So these could be people who are interested in receiving a card themselves, people who are interested in becoming a caregiver, people who are interested in a dispensary license, so on and so forth. On the 27th of August, so next week, application review will begin and food safety standards will be made available. Starting on September 10th, residents of Oklahoma will be receiving their first approval and or denial letters, and licenses will be mailed to applicants. So the important thing to note along with this timeline is that there is currently no date for when medical marijuana will actually become available to those with cards in the state of Oklahoma. Though as soon as September, we could see people with a medical marijuana card, there is no word on when they will be able to buy medical marijuana. So what does this all mean for employers? State Question 788 has a limited amount of information for employers, but they pack a lot into it. Basically, what State Question 788 says is that unless an employer were to lose money or licensing under federal laws, an employer cannot discriminate based on a medical marijuana cardholder status. Employers can continue taking action against a medical marijuana patient if that patient uses or possesses marijuana during work hours or on site at work. Employers cannot take action based solely on cardholder status or a cardholder's marijuana positive drug test. So the key word in State Question 788 is solely. We're going to talk a little bit more about what that means. First of all, can employers still test for marijuana? Yes, employers in Oklahoma can continue testing for marijuana. Nothing in State Question 788 prohibits an employer from testing for marijuana regardless of cardholder status. You can continue testing medical marijuana cardholders as well. Employers are permitted to test all employees within the boundaries of applicable state laws. So keep in mind that Oklahoma has 2 mandatory state laws, both of which place limits on when, how, and why employers are able to test employees, regardless of medical marijuana cardholder status. Can employers discipline and or terminate for marijuana use? So this is where it starts to get a little bit tricky based on the wording of State Question 788. For non-medical marijuana using employees, employers retain all rights to discipline or terminate for a marijuana positive, as outlined within the law. So if somebody has a marijuana positive drug test and is not a medical marijuana card holder, you would be able to discipline or terminate according to your drug-free workplace policy. Recreational use, either outside of work or in the workplace, is strictly prohibited in Oklahoma. For medical marijuana users, there are restrictions that apply to employers, although the law as it currently stands does leave that question a little bit open-ended. So, when can a medical marijuana user be disciplined or terminated? A medical marijuana card-holding employee cannot be disciplined or terminated based solely on a positive test for marijuana and or its metabolites, according to State Question 788. The law isn't exactly clear on what would constitute disciplinary measures or termination in conjunction with a marijuana positive drug test. A marijuana positive drug test alone does not constitute employment action. We can look at other states for guidance as to what could be used in conjunction with a marijuana positive drug test, and that'll give us a little bit of an idea. But until Oklahoma provides further guidance, we cannot say anything with 100% certainty. In other states, having a marijuana positive test while holding a safety sensitive position has shown to be enough to discipline or terminate regardless of cardholder status. State Question 788 does not mention that. Additionally, if the Oklahoma legislature were to say that a safety sensitive position could be used in conjunction with a marijuana positive to discipline or terminate, Oklahoma would need to provide guidance as to what would constitute a safety sensitive position, as they do not currently have a definition for that in their law. And that definition is currently in flux. There are some states that have been proposing laws that would change the definition of safety sensitive in their state. So as we understand it, that definition is changing as well. So Oklahoma would need to provide further guidance for employers were that to be the case. However, what we do know is that should a medical marijuana user return a marijuana positive test that is also positive for other drug metabolites, that puts that employee in violation of your company's drug-free workplace policy, you would be able to discipline and or terminate according to your policy. If marijuana is brought into the place of work or is used while at work, employers are permitted to discipline or terminate regardless of cardholder status under State Question 788. Additionally, any federally regulated employer is required to stay in compliance with federal regulations and should continue acting as such. This means that in Oklahoma, if a medical marijuana card-holding employee that works in a federally regulated position were to return a marijuana positive drug test, they are not exempt from discipline or termination despite what State Question 788 says. In this particular case, federal regulations still rule and employers would act accordingly. However, there is proposed legislation on the federal level that would make it so that federal employees cannot be disciplined for marijuana use within the bounds of their state laws. And if that were to pass, then State Question 788 would apply to these employees as well. Unfortunately, at this point, there's not much guidance for employers, and what there is fairly confusing. What we can hope is that more guidance is in the pipeline that will kind of give us more ideas as to what employers' rights are and will continue to protect employers. So, as I stated, we can look to states with similar medical marijuana language, and they might be able to give us some idea of what we can look for in Oklahoma. Maine is one such state that has similar legislative language. Maine's law states that an employer may not refuse to enroll or employ or penalize a person solely for that person's status as a qualifying patient, unless doing so would put the employer in violation of federal law or cause the employer to lose a federal contract or federal funding. Once again, as with State Question 788, the keyword here is solely. The law goes on later to clarify that an employer is not required to accommodate the ingestion of marijuana in the workplace or the employee working while under the influence of marijuana. So it is very similar to the wording of Oklahoma, except for the addition with Maine's language that an employee cannot work while under the influence of marijuana. The Maine Department of Labor has gone on to provide clarification for employers in the state, which is something that we can hope that the Oklahoma Department of Labor might do. The Maine Department of Labor has said that employers may prohibit the use or possession of marijuana in the workplace. Employers may discipline employees that are found under the influence of marijuana in the workplace. And they can enact and enforce workplace policies restricting the use of marijuana while in the workplace or in the course and scope of employment. However, they did not provide a definition as to what would constitute an employee being under the influence. And they did not provide further guidance for Maine employers as to what could be used in conjunction with a marijuana positive drug test in order to constitute employment action or termination. Minnesota also has similar language to Oklahoma. So employers may not discriminate based on a marijuana positive drug test that is returned by a medical marijuana card holder, unless the employee used, possessed, or was impaired at the place of work or during work hours. Minnesota is another state that does not provide guidance for employers as to what could be used in conjunction with a marijuana positive drug test other than the use, possession, or impairment during work hours. And the last state that we're going to look at real quickly is Arizona. So Arizona is fairly similar to State Question 788 as well. Employers are not required to allow the ingestion of marijuana or permit employees to work while under the influence. And a registered marijuana patient is not to be considered under the influence of marijuana solely based on a marijuana positive drug test. Once again, the key word in this law is solely. The law does not provide guidance as to what could be used in conjunction with a marijuana positive drug test, and the legislature hasn't provided any further guidance either. However, what Arizona's law does do is that it has provided employers in the state with a definition for impairment that employers can use to guide their policy wording. Their definition of impairment includes symptoms that somebody may be under the influence, such as speech, walking, standing, physical dexterity, agility, coordination, actions, movement, and more. Negligence in operating equipment, disregard for the safety of themselves or others, involvement in an accident. The list is quite long that the state of Arizona gives. So although employers are not given a strict example of what could be used in conjunction with a marijuana positive test, nor are they given guidance as to what would quantify sufficient concentration to cause impairment, which is what the law says, they are given a definition of impairment that can be used to guide their policies. Unfortunately, Oklahoma's law as it stands does not provide that impairment be a qualification as to what would constitute appropriate disciplinary action in conjunction with a medical marijuana positive drug test. But as the legislature meets and starts to flesh out more of the medical marijuana laws in Oklahoma, we might see something like this. Now, the point of looking at these three states is to say that Oklahoma is not the only state that has some gaps in their legislative process when it comes to medical marijuana and employers' rights. Hopefully, Oklahoma employers will soon be provided additional guidance that will provide them with more information on what their rights are and a list of what is and is not allowed. But in the meantime, you only have what is within State Question 788. So what does that mean for you guys? What do you need to do as far as next steps? Well, you need to know what the timeline is looking like for medical marijuana in Oklahoma. So as I stated earlier, applications are now available on the Oklahoma Medical Marijuana Authority website, and people are going to start receiving medical marijuana cards as early as September 10th. As I stated before, there's no date given for when medical marijuana sales, growth, etc. will begin in Oklahoma. And due to the current legal battle surrounding medical marijuana in the state, it's likely that we will not hear anything on a program start date until all of the legal issues are ironed out. So I mentioned these kind of legal issues in Oklahoma. So they all stem from how the question was passed. So State Question 788 was passed with particular wording, and the legislature met in an emergency session and passed emergency rules on July 10th. So many proponents of legalization were upset about what those original emergency rules stated. They placed limits on THC levels. There was a ban on the sales of smokable marijuana. There was a requirement for dispensaries to have a pharmacist on staff, more things along those lines. And almost immediately upon the passage of these original guidelines, 2 lawsuits were filed against the state. Attorney General Mike Hunter stated that the legislation exceeded its authority with some of the additional rules that the legislative body put in place in order to provide a safe environment for people in the state with legal medical marijuana. And that was the crux of the issue. Additionally, there are some other legal issues. The health department's former general counsel has had to step down, as well as the executive director of the Oklahoma State Board of Pharmacy, because of issues relating to medical marijuana. So with all of that said, they had to completely pass a new set of emergency rules, which were just passed on August 6th, so earlier this month. These rules rolled back some of the additional measures that were put in place by the legislature, and they have widely been more approved by marijuana legalization advocates. However, they need to undergo further activities in order to complete the permanent rulemaking process. It's likely that there will be no further changes to this set of rules, but we could still see some depending on how the Oklahoma Medical Marijuana Authority decides to move forward. Medical marijuana legalization advocates are not overjoyed with this set of rules, but they're much happier with them than they were with the original set that was passed. There haven't been any more lawsuits filed against the state because of these as of yet, but there could still be some filed against the state down the road. Governor Fallon, Oklahoma's governor, has stated that she is not going to call an emergency legislative session. What this means for employers is that hopefully the next action that you will see in terms of guidance for employers will be in February 2019 when the next legislative session is called to order. Already, just last week, there was a letter that went out to the legislature from a lawyer that had a list of things that they needed to address in the state. Included in that list were employer and employee rights and flushing out medical marijuana in the workplace. So it is definitely on their radar. However, the legislature talking about this could be pushed back because of these lawsuits, and if there are any additional lawsuits filed, that could push back that timeline even more. So I'm going to turn the time over to Frank to talk a little bit more about next steps for employers.
Thank you, ma'am. As we talk about next steps here at DISA, what's really important for our customers and for you is to really focus on your policy. And when we talk about your policy, here's some suggested actions or items you can take. If you don't have a drug-free workplace policy in place, now is the time to work with a policy expert to create one. If you do have one, of course, I would strongly encourage you, now is the time to review it with a policy expert to ensure that you are up to date as it relates to Oklahoma and the unique challenges of Oklahoma. Make sure to outline your testing procedures, outline your disciplinary measures, and so on. You want to do this so that you ensure that the expectations are clear to current and prospective employees. We also would encourage you to stay up to date as it relates to how the law in Oklahoma is progressing. As you can already tell, Oklahoma's law has gone through a variety of iterations, and it is definitely expected to go through more before truly being finalized. I would encourage you to visit the Oklahoma Medical Marijuana Authority for up-to-date information on what the state is currently working on. Let me repeat that. I would encourage you to visit the Oklahoma Medical Marijuana Authority for up-to-date information. And we believe that more guidance for employers will be forthcoming in the very near future. As we talk about medical marijuana in Oklahoma and potential next steps, I'm going to encourage you to contact your local and state representatives. This will help ignite action in the state by reaching out to the Medical Marijuana Authority, the Department of Labor, the Attorney General, the Governor, and more. I would ask that you voice your concerns over the liabilities that employers are currently facing as it relates to the wording of State Question 788. I would encourage you to ask such things as, when can an employer take action if medical marijuana is being used? What constitutes a safety-sensitive position? What constitutes impairment? I would encourage you to ask for further guidance to ensure that our workplace, your workplace, is a safe place for both employees and the general public. If you need sample letters as it relates to reaching out to the local and state representatives in Oklahoma, here at DISA, we've provided that for some of our clients, and we can help and assist in that particular matter. I'd ask you to contact the above representatives, as I talked about, the governor and the lieutenant governor, etc., via letter. And if you are able, try to schedule an in-person meeting or phone call if possible. Legalization advocates are doing the same thing, so it's pertinent that as business owners and employers in the state of Oklahoma, you do the same thing as well. With that being said, next slide. So as we move forward, if you have further questions or any questions, I'm going to make a recommendation that you send your questions to thomas.hafner@disa.com. Let me repeat, thomas.hafner, Hafner, @disa.com. If you have questions based on this presentation today, or if you need further guidance. Also, please feel free to visit DISA Global Solutions at www.disa.com. Once again, www.disa.com. And I'll now turn the call back over.
Thank you, Frank. On behalf of DISA Global Solutions, we hope that you found today's presentation informative and helpful. As Frank mentioned, questions for today's presenter or regarding this content should be directed to thomas.hafner@disa.com. And for those of you who have submitted questions on this call, those questions will also be included with others that are submitted, and Thomas will have those directed to the right place. Also, we wanted to remind you that today's presentation has been recorded, and we will send you information on how to access that recording. With that, we will conclude today's webinar presentation, and we thank you for your attendance. Have a wonderful day.